This is the McDonald family here. This is John and Brandy, and this is Alexander here in the middle.
All right, everybody's going to testify. Raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth to help you God?
Yes, ma'am.
See, that's part of the job of a father, is to tell his son what his right hand is and what his left hand is. So he'll help you figure that part out. All right, Mr. Knowles, go ahead.
Brandy, I'm going to start with you. Please state your full name for the court.
Brandy Wyoming McDonald.
And are you the mother of Alexander Earl McKinnon?
Yes, I am.
And is Douglas Earl McKinnon the biological father of Alexander?
Yes, he is.
And you came to my office and we drafted a petition for adoption by a step-parent with consent. And Mr. Douglas McKinnon executed that document.
Yes,
Correct?
that is correct.
He also executed a notice of informed consent. And you're here today to present this petition and ask that your husband, John Wayne McDonald, be allowed to adopt your son, Alexander.
Yes,
Do you believe that is in Alexander's best interest?
yes,
Are you and John financially, physically, and mentally capable of providing for Alexander?
yes.
And has John served this role for some time, his father?
He's been in his life for 5 years. So, yes.
And do you believe it's in his best interest,
Yes.
Alexander's? Now, do you understand that in the event that you and John were to divorce, that either of y'all could get custody?
Yes,
Either of y'all could pay child support?
yes,
And you're willing to accept that and believe it's in his best interest?
yes.
Will you please state your full name for the court?
John Wayne McDonald.
You can come over in front of the microphone if you'd like.
John Wayne McDonald.
And Mr. McDonald, did you hear everything your wife said?
Yes, sir.
Do you agree with it?
Yes.
Do you understand that in the event that you and Brandy were to divorce, either of you could be responsible for child support?
Yes, sir.
That either of you could receive custody of the minor child?
Yes. Yes.
And that from this point forward, he would be an heir at law of yours and you would be an heir at law of his if the court grants this adoption?
Yes, sir.
And do you accept all of those rights and responsibilities?
Yes, sir.
And do you believe that to be in Alexander's best interest? Are you asking to change his surname from McKinnon to McDonald?
Yes.
And his name will be, if the court grants this, Alexander, Alexander, Earl, Earl, McDonald, MCD, Donald.
Yes.
Is that correct? Now,
You heard the judge ask whether Alexander is an Indian child. He's referencing ICWA, a federal law that adds extra protections when a child is a member of, or eligible for membership in, a federally recognized tribe. If ICWA applied, the adoption would have stricter notice and placement rules. Here they confirm it doesn't, so the case proceeds under state law.
Brandy, Alexander is not an Indian child, correct?
No.
Native American child.
No.
Okay, and he's not been brought into this state for adoption purposes in any way.
No.
Y'all reside here in Humphreys County, Tennessee.
Yes.
What's your name?
Alexander Earl McKinnon.
Okay. Did you hear what these folks said today? Is this your mom? Is this your stepdad? Do you want him to adopt you?
Yes.
You do? Okay. You good with your name changing?
Yeah.
Okay. Judge, that's all the
I
proof.
rarely see anybody quite as excited as he is to appear in front of me, but I'm glad to see that he's happy about the situation. Mr. McDonald, the main thing that I have to make sure of is that you understand the change in your status that will result after today. Being a step parent is a difficult job sometimes, and it's a compliment to you and to Mrs. McDonald that the two of you have such a good relationship, and you've had such a good relationship with this young man that he wants you to be his father. And that's a huge compliment to a stepdad. So we'll be changing the nature of this situation today, and that will be changed from that of a step parent to that of the same as if you were his biological father. So in every way, shape, form, and fashion under the law, he will be your son. And you understand that? Do you have any other children?
Yes, sir.
How many children do you have?
I have 2 more.
All right, you got any boys? All right, so you know what you're getting into, so.
I was adopted myself.
Oh, you were? Well, then you understand that this is what they say, paying it forward. I think that you're able to return the favor to a young man who obviously looks up to you in every way. And I'm certain that as the years go by, this will only solidify into an even greater bond that the two of you have. So, Ms. McDonald, it's a great compliment to you that you have a young man that looks up to his stepfather so that he wants him to be his dad. And I am happy to grant this. Ms. Honeycutt, you arrived. Are you involved in this?
I was the guardian. I've been his guardian ad litem for many years. I was the guardian ad litem in the underlying case. So I'm happy to see this happen. And then I have a motion to approve attorney fees in the underlying case as well. Ms. McDonald has already paid her portion, but I submitted the invoice so I can send a bill to Dad.
Okay, well, everything seems to be in order, and I'm happy to grant the adoption. So congratulations.
Thank you.
Thank you. I assume I can draft an order for the approval of the
You can.
Congratulations.
Is that okay, Judge?
Yes, absolutely. Come on up here. We'll let you sit in the big chair if you want to. We'll all stand on one side. So what do you want to do? You want to sit?
Yes.
All right. You want the gavel? There you go.
Oh, man.
There you go.
All right, guys. Here we go. 3, 2, 1. All right.
Congratulations.
Appreciate it.
Congratulations to you. Take care. Xander, you can carry this with you, and that'll be your own individual gavel you can use in school. You're welcome.
I got the band.
All right.
Good morning. You are Jackie Lynette Holland.
Yes, sir.
Raise your right hand. Let's place your hand.
Do you solemnly swear or affirm that the testimony you shall not give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Great catch by the court. An order of protection isn't the same as a criminal no-contact bond condition. One is a civil protective order with its own statute. The other is tied to a criminal case. Mixing them up can wreck a case file. Comment: have you ever seen courts or paperwork confuse these terms?
Ms. Holland, you have filed a request for a divorce, and there's some issues with the complaint that you have filed because on the second page of your complaint, there is a provision under paragraph 7 that states, orders of protection and other orders, check the box that is true to you. And the first box that was checked is there is no order of protection. And then down below that was checked there and initialed, yes, there is an order of protection now in this court. It will stay in effect until the divorce judge changes it.
Okay, there's not an actual order of protection. There was an order attached to domestic violence, a no contact order attached, but not an actual order of protection.
All right. And there is no restraining order other than the statutory injunction. Is that correct?
Correct.
So your complaint contains certain statistical information. Is that information true and correct?
Yes, sir.
You've also filed with the court a marital dissolution agreement. That marital dissolution agreement purports to bear your signature and that of your husband's. Is that your signature?
Yes, sir.
Is that your husband's signature?
Yes, sir.
Do you believe that agreement fairly and equitably divides all your property and distributes all of your debts? You have provided me with a final decree. I need just a moment to look it over. An order of protection is not is a peculiar matter that is before the court under a specific statute. What you're talking about are bond conditions in a criminal case. I've changed that to indicate neither party has a current protective order, but bond conditions apply. I've signed your final decree. You can get a copy of it a little later in the morning, and you need to mail a copy of that to your now ex-husband. Thank you.
Your Honor, this is Ms. Duke's motion to continue. I don't oppose it. We just need a date to reset it. Are you available the 14th of July?
I can't say anything else.
Okay.
That's all right.
Well, I
You can't say anything else on.
that's when I had originally said it, and then they told me I couldn't set it that day. I still had it down on my calendar. I had it on both.
Apparently, Judge Wallace Ms. Advisor cannot set anything else on that day.
You need another date?
We do need another date just to set it in case we can't agree, but I think we'll probably be able to reach an agreement on it.
I don't think Ms. Roberts is available in August, the date that we have.
On the August dates, those are double dates, and I've already got everything set.
September 3rd.
You also have a Jones versus Jones case that's next, and you have a motion to continue in that.
I do.
Yes. And our only issue, and I don't know if Your Honor reviewed the motion, is the mental health of the minor children. It'd be the only reason that we would need to
What's your
press
reason? I
forward.
haven't looked at the file yet. What's your reason for a continuance in that case?
Well, there was two reasons. Number one, inappropriate notice. We got it on Tuesday. Under the rules of civil procedure, we're entitled to 5 days notice, 5 working days notice. We were not provided 5 working days notice. I got it at 5:03, emailed to me. And again, just getting ready for it. Ms. Duke has made some accusations that are going to take this will be an all-day hearing.
If I may briefly respond, it was sent by certificate of service on the 18th, and so we complied with the rules of civil procedure, and then I also emailed it at 2:00 on the 23rd.
So
So
we
what are
emailed 3 days.
what are your issues regarding the urgency of it, Ms. Duke, in the Jones case?
A few of the minor children are going to have to be in significant therapy based on the continued threats of the father and the bad mouthing of the mother and some things that he's doing to try to manipulate the children.
And that's
The
contested.
children are here if Your Honor needs to hear from them.
And again, the second reason is I had a deposition scheduled with Ms. Duke's law partner at 11:00, but late Friday afternoon, Mr. Vandervoort filed a motion to continue, and we heard that in front of Judge Turnbow, and he granted the continuance. So that was the other reason for the continuance in my motion, but that resolved itself. But it did lead to the fact that I got this and had no time for preparation, and so we just need to continue.
What about the 9th of July?
The 9th of July, I have Judge Lockhart Mashes in Dixon, and I have
I'm
Carbone
thinking
versus
is give you
Carbone.
a date for both of these that you may have to hear it out of county because someone else will be here in July.
Judge, may I approach off of the video?
I don't like for everybody to know that I'm going out of town from the 5th through the 12th of July.
That was the reason we were moving Butler.
Yes.
18th of July,
This is all contingent upon you agreeing to hear it out of county because I'm going to be in Cheatham County, but I have that date available. And other than that, I could give you
as far as I know, I try to keep Fridays
the
open.
29th.
The 29th, again, that's Judge Lockhart Mashes, Dixon, Chancery, and I have a Bradford versus Bradford, and then a final hearing in a Crispin
I'd
versus.
rather hear this one on the 31st than just bump to the Bates case.
Now, I can do the 18th. I don't know that. one's due.
I have a matter that the Hickman County Court set, but I will file a motion to continue on that one. So I can do July the 18th. It's important that this be heard.
And we're doing Butler mediation on the 16th of July. So hopefully we can get a date on it. We'll just work together to get a date on it after the mediation.
All right, so at this point, we're gonna set the Jones case that Ms. Roberts is asking for a continuance on the 18th of July.
Yes, and can we admonish both of the parties to verify that nothing is to be said about this? That is our major issue. The kids are.
This is the judge drawing a hard line. Do not involve the kids. Family courts run on the best interest of the child standard, and coaching or venting to children can backfire fast. The hint about appointing a guardian ad litem means the court wants an independent voice for the kids. Smart move or overreach? Sound off.
Calling and crying, and we would assert that we've got text messages to back up everything that's been said in our motion.
I'm not gonna assume the facts in the case. Are the parents here, both sides?
They are.
Bring them up.
You will keep your hands out of your pockets, please.
Mr. and Ms. Jones, we're moving heaven and earth to get you a date to hear this motion that's been brought up, and there's been allegations that have been made by both sides about the situation. What I'm not assuming that any of those facts are true, but what I'm going to tell you is this. I'm putting an order down today that you two are not to discuss this case with the minor children, period. You know, if the quote, is there a guardian ad litem in this case?
I think we need one at this point, Judge.
I'm not opposed. I don't know that there's funds available to do it. It's a private case, but if we're never opposed to one, that's fine. We would just ask that both parties be ordered to make a deposit with that guardian ad litem up front.
Well, the reason the guardian ad litem is even being discussed is because of the fact that you've got minor children in the middle of this. You both may be fine people. You both may be good parents in your mind, and that's good. But my main concern and the main issue that I have in this case is to protect the best interest of the minor children. So if that causes me to have to come down hard on one of the two of you, so be it, because my interest is trying to protect the children. But by the same token, children are very perceptive and empathetic to their parents. And if they see one of their parents upset about something, then they naturally will, you know, try to side with that parent, and they will naturally try to empathize with that parent. So let's try to shield the children from whatever's going on between the two of you. Let's don't involve the children. And I say it in a very nice way, but I'm telling you, I'm ordering you not to involve these children and not to have the children influence, not to discuss this case with you about this. If they have questions about it, you just tell them, honey, I can't discuss it with you because that mean old judge told me he'd put me in jail. You don't have to say it like that, but that's exactly what will happen. If I find out that you two have broken my order, then I'm going to put you in jail, because I fully and firmly believe it is in the best interest of your children not to be put in the middle of this situation. Children are, you know, used to having both parents. That's the home environment they had, and now that's blown up. Why wouldn't they be upset? I mean, that's a natural reaction to the fact that what they thought was their cocoon of protection and the home that they had is now no longer there, because their parents can't get along and they're going to go through a divorce. But under the circumstances, you two can still make it okay for your children by protecting them from being exposed to all of the negativity that a divorce naturally brings about. Allegations may be made. Those allegations would have to be proven in court. I understand that children may be called to testify. I think that's a very regrettable, but sometimes a very necessary step to be taken. But that's the reason that I'm considering a guardian ad litem being appointed, is the fact that the children need somebody to advocate on their behalf. Now, Mickey Furlong Smith is the one that I generally use in a lot of cases. I would simply suggest, since I've set this hearing for the 18th, that you two need to check with her and make sure she's available. Before, I know she's out of town right now.
She's in Chicago right now. Yeah.
So it would be my opinion that you need to check with her and see if she's available on the 18th. If not, we need to get somebody else that is available.
Yes, sir.
And there are other individuals who can do that. Lynn Coffinberry is another one that we use on a regular basis. But let's find a guardian ad litem that's available on the 18th so that we can do this.
Yes, sir.
Where are we going to hear this? Which courthouse?
Courtroom 5 in the Justice Center,
In Dix. Okay.
Charlotte, Tennessee.
You just said you were in Cheatham, but you're going to be in Dix.
Right.
And again, some guidance, Your Honor. Again, as you are well aware, children and their electronics to stay or something that I didn't necessarily grow up with, but punishment issues when you're taking electronics away from children because of misbehavior, whatever, does that include cell phones? And then escalates into, oh, you've taken my cell phone away from me.
My client doesn't have a problem with that at all.
So again,
But if she's explained to the children, if you've done something, Dad can take phone away. Yeah, absolutely.
Put it in the court order that one of the avenues of punishment. How old are these children?
they range.
We've got 16 and 11 right now.
Well,
There's a set of twins.
I'm of the opinion that if they are misbehaving and there's some reason to do that, taking their cell phones away is better than having a leather belt across the rear end like my father used to do with me. So I think that would be certainly permissible, and the children need to understand that that is not an abusive exercise of parental authority.
And go call the other one on somebody else's cell phone and say, somebody took my cell phone away, and I made them.
Put it in the court order that the court authorizes both parents to take the children's phones away if in an appropriate situation as parental criminal
My-
discipline.
I will assert with the court that my client has absolutely no problem with that, but it was discovered that one of the children was confiding what was going on in dad's home, and that's when the child's phone was taken.
And that is highly disputed when and again, that's what they want you to believe, Judge, and I know you're not listening to that, and that's why I ask in a generic sense. I'm not trying to prime the pump that Ms. Duke is trying to do. It's disputed.
You two are good lawyers, but you are kind of like oil and water. And under the
Good
circumstances,
and bad. I realize that, Judge.
it is yin and yang, is that what you said? And there is some truth to that, whether you like it or not. But under the circumstances, I'm not assuming any of those facts are true. I'm trying to give you an opportunity to be heard where we can establish what the facts are. So let's just try to maintain the status quo and keep the children protected to the best of our ability until we have that hearing.
Yes,
All
sir.
right. Thank you.
Thank you.
Thank you, Judge.
Morning, Mr. Johnson. Raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
You are James Glenn Johnson.
Yes.
Mr. Johnson, you've asked to change your name, and I need to ask you some statutorily required questions. Are you asking to change your name to avoid your just debts or creditors?
Yes,
Are you asking to change your name to avoid criminal prosecution?
yes,
You have stated the reasons why you want to change your name to William Glenn Stevens Johnson. And is that reason the reason that you're asking to change your name?
William Glenn Stevens was my birth name, and I'm asking to reclaim that.
Okay. So do you want your new name to be William Glenn Stevens Johnson?
Yes.
All right.
And I attach the Johnson because I've got two signs, successive registered for kids.
I understand.
Yes.
I'm going to ask you, if you will, to sign the order where it shows that you've approved that, and you signed the new name as well. So, I'm granting your name change, but you'll need to sign to approve that where the X is there
So sign with
with your new name, William Stevens Glenn Johnson. William Glenn Stevens Johnson. All right, Mr. Johnson, I have granted your name change and signed your order. You can get a copy of it a little later in the morning once we've transmitted it over to the clerk's office. Okay.
Yes.
All right. Thank you.
2025 CV 69 regarding Kylie Ottenreed.
This is here today on an order of protection and a hearing to determine whether or not the order of protection should be issued for a longer period. It was an ex parte order of protection that was issued back on June the 2nd, and this hearing is designed to determine whether or not you want to have that order of protection extended for a longer period. Do you wish to have that extended?
Yes, sir.
All right. Then we'll have to have a hearing. You have the right to an attorney to represent you, since Mr. Whitfield is represented by counsel. Do you wish to hire a lawyer?
I'll hire one, yes, sir.
All right. Are you asking for this matter to be reset for you to hire a lawyer?
Yes, sir.
Ms. Roberts, she's asking to hire a lawyer, and I think it's probably in her right to do so. When's the next chancery date after the day?
Well, Your Honor, I'm not aware of any statute that grants her the right to extend the order of protection past the 15 days that it's done. So understanding that if she wants to hire an attorney, then we are not agreeing for the extension of the ex parte order of protection.
An ex parte order of protection is extended by statute for 15 days from the date of issuance, unless it's extended further. To extend it further, we would have to have a hearing, and that hearing would require testimony to be taken from you and from Mr. Whitfield. And under those circumstances, then you are putting yourself at the issue of that. Resetting it means that this order that was issued ex parte would be expired by statute, but that you would still have the right to come back in on the next day I give you and to have a hearing to determine whether an order of protection should issue. Do you understand that?
Yes, sir.
And that would give you an opportunity to consult with an attorney and determine whether or not that should or should not be done.
Yes, sir.
Then when's the next first available date?
So the lapse will be on the 15th, the 5th of July, Your Honor. The parties have a minor child. So
The first thing after the 5th is July 7th.
Let me see.
we have just taken Butler off July 7th. I've got to be here.
You have?
Well, in the morning, I do. I have a Brighton, James, and a Harvey matter. They're
We'll
short.
set it for July the 7th in front of Judge Wallace. You need to consult with an attorney as quickly as possible and have your attorney contact Ms. Roberts. Perhaps the two of you can through your lawyers, can arrive at some sort of an agreement. Okay.
Ms. Shaw, I have a petition to establish paternity that will be served on her.
All right.
That is
And
out.
another reason you need to go ahead and hire yourself a lawyer as soon as possible.
Yes, sir.
All right. July 7th.
Yes, sir. Thank you.
There we are. All right. Let me take a moment to look and see what this is about.
Yes, sir.
All right, my understanding is that Mr. Thornberry has filed this Rule 60 motion on February the 21st of 2025, seeking to correct an order that was entered on October the 22nd of 2024. His basis is that the parenting plan that was shown in that final decree or that order that was entered listed his income at $5,083.33 per month, when his income has been zero since April of 2024, since he's been incarcerated on pending charges, and that he's asking for the relief to amend the financial support section of the plan to acknowledge that he has no income. So, Mr. Thornberry, if I stated correctly what your statement is.
Can you say that one more time? I'm sorry, the audio here is not really good.
I understand. It's my understanding that you're asking to amend the parenting plan that was entered back in October of 2024 because of the fact that it incorrectly lists your income at $5,000 plus and that you have been incarcerated since April of 2024 on pending drug charges. Is that correct?
Yes, Your Honor. There was a few other points that I wanted to try to address while we were here today, but that was one of the main ones that I had sent in. I had sent in a few motions to the court that the clerk's office had received. One of the other things that I wanted to address, if I can speak freely.
Well, if you're going to testify about what you want changed, then I need you to raise your right hand. Let me place you on the oath. Do you solemnly swear or affirm the testimony about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
What else are you asking for?
I was going to try to address the no contact order that the plaintiff has said has been in effect since we last went to court. I wrote a cease and desist letter that I actually sent to Mr. Hawley and to the clerk's office, asking them to, let me know about the no contact order that the Christie said that she had. I wrote the clerk's office asking them to send me anything on file that they had saying that there was no contact order. Our parenting plan doesn't have a no contact provision in it or anything. I haven't been allowed to talk to my daughter for the duration of my stay while I've been incarcerated. And the second point that I wanted to see about is letting my dad, who's here in the courtroom, and my stepmom utilize my parenting time so that I can adequately visit and communicate with my daughter. Because I don't believe that at this time that the mother will be willing to accommodate those. That's all, Your Honor.
All right, Mr. Hawley.
Judge, we did not know it was
You
set
need
for
to
today.
speak before the microphone for him to hear you.
I think, we didn't know that it was necessarily set for today. I don't know if it was set today to get a date to hear his motions or whatnot. Mrs. Thornberry's not here. I haven't reviewed the file, so I'm shooting for the cut. But I would say, number one, we would be opposed to him reducing his income. Obviously, it's what he should have been making. He's in jail right now, and of course, the rearage is still sitting there. I understand it's a zero income, but he's there on drug charges and domestic violence charges and things of that nature.
The court suspends child support calculation while the parent is incarcerated, but doesn't reinstate visitation. Support math can wait. Safety and logistics can't. That distinction often surprises people. Prediction time. On the October review date, what's the likeliest outcome? Modified support, supervised visits, or status quo?
Nonetheless, to have
According to his information, he was in jail at the time of the last hearing, and it does show that when an order went down to suspend his visitation, that he was actually appearing by Zoom from the Dixon County Jail on that occasion. So my belief is that clearly, if he was incarcerated, I understand your argument about the fact that he may have a willfully unemployed or underemployed that you may have that argument to make because he's incarcerated, but it's pointless to set a child support amount when he is unable to do it. Mr. Thornberry, I'm not asking you to go into the facts of the case, but according to my review of the file, it appears that you are charged with 2 counts of attempted first-degree murder and then some drug possession charges. Is that, without telling me what happened, is that the charge that you're facing?
There's 3 counts of attempted second degree, 1 count of Schedule 1 drug possession, 2 counts of domestic, and then 1 count of resisting arrest.
Let me just deal with this first and foremost. In my opinion, the suspension of your visitation has been properly heard by the court. You were given an opportunity to be present, and there's no basis to set aside that order because of the fact that you are currently incarcerated facing very serious charges. The order states that the suspension of your visitation would occur until such time as you are released from incarceration. Now, what that means is that as long as you're in jail, then you're not going to be able to see your children. Now, whether or not grandparents have a right to visit under a statute, that would be determined. The grandparents would have to file a motion for a visitation under the grandparents visitation statute, and that has not been done in this particular case at this point. But I cannot simply substitute your parents for you as far as the visitation goes. So under the circumstances, it would seem to me that the best thing I can tell you is I am going to suspend any order that sets his visitation or his child support at the current time based upon the fact that he is incarcerated and was incarcerated. I will suspend any operation of any child support order until such time as there could be a further hearing, and then that will give you an opportunity to have your client. I'm not back here until October, so it would be October before that portion can be heard. When it, again, not going into the facts of the case, but you have a lawyer, I assume, that's representing you on the criminal charges.
Yes, Your Honor. I go back to court October 28th.
Roger Wayne.
Yes,
Roger.
Yes, Your Honor.
All right. Then you need to contact Mr. Winnick and just, explain to him what's going on. But I don't want to have you testify about your criminal, where you'd be subject to a cross-examination. And so for that reason, I'm just going to put an order down that suspends the operation of the parenting plan as to the child support calculation based on the fact that you're incarcerated and have no income at the present time. Your motion to alter or amend or do away with these no contact order is respectfully denied based upon the fact that you're incarcerated and have, in my opinion, there's no basis upon which I can find that there's any change from the prior hearing. So you can renew that if you choose to by filing something and having it set in October. But if you want to have this child support issue heard in October, we can set it on a day in October. Give him a date, please.
We could do October 1st.
October 1st.
I'm fine on that day.
We're going to set it on October 1st for us to review both the visitation aspect as well as the child support issue. Okay?
Okay.
10:30?
At 9.
At 9? Okay.
Well,
9 o'clock?
You said October 22nd, is that correct?
No, October the 1st.
Okay.
That's the date. All right. Thank you.
If I'm correct, Judge, you're suspending basically the collection part of the child support, which is fine. We weren't.
Calculation of child support under that parenting plan is suspended based on the fact that he was not employed at the time that the order went down and has no income. So as a result of that, since he's still incarcerated, I think it's pointless to have that calculation in place. So we're granting your motion regarding calculation of child support until a hearing on October the 1st. Mr. Thornberry?
So the child support that's in arrears right now, is that going back from whenever the new plan went in place or from this day? Just for transfer.
I have found that the child support calculation was an error based on the fact that you were incarcerated at the time, and therefore it should not, but we'll deal with that on October the 1st.
Okay. Thank you very much, Your Honor. I hope you have a blessed day.
Thank you.
Thank you, Judge.
Call the next case.
2025 CV 49, Tommy King Jr. versus Megan King.
Good morning. Anyone who's going to testify, raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
This is petition to change the name of a minor child, is that correct?
Correct.
And you are the minor child? Don't look that minor to me. How old are you? 17. So are you consenting to this name change? And who is the biological mother?
I am.
You've all been placed under oath. Do you testify that you're asking to change the name of your daughter to avoid any criminal prosecution or to avoid any payment of debts?
No.
Right. My understanding is that the last name is Alton Reed, is that correct?
Reed.
That she was given that name at birth, but that's not the biological father's name, is that correct? Right. And we're asking to change it to Kylie Nicole Elam. All right. And Ms. Elam, you are in agreement with that change, is that correct? And of course, Wesley Alton Reed has signed off on the agreement as well. So, all right. I will be glad to change your name. I always make that offer that I can change your name to anything you want it to be. You want it to be Beyonce Elam or Taylor Swift Elam or anything like that. So you're happy with Kylie Nicole?
Yes.
You submitted an order signed off on by both Wesley Alton Reed and your mother. So I signed your order. You can get a copy of it from the clerk.
Thank you.
Thank you. Thank you.
Good morning, Your Honor.
We skipped over the McDonald one, but that's because we did that. All right, this is the King versus King.
Yes, Your Honor, this is my case. Mr. King is present in the courtroom, sitting back here to my left. This is a divorce case. I see on the docket there's been a motion to continue. I didn't get a copy of that, but I see that it's in the file. I've looked at that this morning. So this is a divorce case that we filed. Mr. King's wife filed a divorce in Utah prior to our filing the divorce case here in Humphreys County. Mr. King has retained counsel in Utah and has challenged jurisdiction and venue there. There's a hearing set, I think in a couple of weeks, maybe July the 15th in Utah regarding that issue there. That's kind of where we are today. What's on the docket, other than the motion to continue, is my client's motion for some temporary parenting time. He's not seen his children in person since she left and took the children back to Utah, and so that's obviously something that he's desiring very much. So that's the status of the case, Your Honor.
Good morning, Your
Good
Honor.
morning.
Abigail Lang for the respondent. We're just asking that we continue this case until the motion to dismiss in Utah is decided upon. We believe that this case should be in Utah anyways, but obviously there's filing here for divorce here as well. My client filed in Utah in March. This was not filed, I believe, until May. So we're just asking to let us figure that out first before we have to maybe come down here for potential divorce and custody proceedings.
Well, obviously, it's kind of pointless in a sense for me to have a hearing if, in fact, Utah is going to assert jurisdiction and the facts support that finding. So it does seem to me that the more beneficial way of handling it, although I have had a case recently where we went forward with the hearing and I concluded that we did have jurisdiction, but that was essentially before me on a question that was raised by both parties as to whether or not this court had jurisdiction or the court in another state had jurisdiction. And after I heard the facts, I found that Tennessee had jurisdiction, and I put an order down to that effect. And the same request was made that California, in that case, had jurisdiction. And California court had a hearing, and I just simply made my findings and reset the matter for the California court to decide what they thought, and the California court found that Tennessee had jurisdiction and did dismiss that action. So it seems to me that in this particular case, unless we're going to go forward today with a full hearing about the question of who has jurisdiction, that we can reset it after that July 15th date and let the Utah court make a determination, and then after that, we'll know where we are. So doesn't rob me of jurisdiction just because Utah has asserted that they have jurisdiction. So we'll see.
I'll supply everything to his attorney in Utah in case that court thinks it needs to speak.
There is a provision of the law that the Utah court can reach out to me to determine whether or not we can agree on which court has jurisdiction. So, and I've had those conversations on a number of other occasions, but in this particular case, I have not been contacted by the Utah judge to know that. So if there is a request for that, then I'll certainly be glad to do that.
And depending on what happens, I take it that I know you'll be back here in October, but you haven't heard anything related to this case. So
you can set it in front of any judge after that determination is made in the state of Utah. I don't have to hear it. So.
Okay. Thank you, Judge.
Thank you.